How is that pronounced?
Gullotty.
It is Koch. Okay, I've seen it both ways, and that would have been probably the second preferred. We are here today in regard to Judy Koch Gullotty versus Therese A. Pascuzzi. You can tell my inclination for names that aren't Jones. How's that? We are going to have the standard time period today. There will be 20 minutes per side. You can use that as you deem appropriate. We would ask that if you intend on saving any time for your for any rebuttal, that counsel, that you do so. This is not your first appearance here, as I remember. There you go. But it is up to you to do that, to save your time. And I can't think what else I haven't said. But we have read the briefs. We have conferenced the matter just in the last few minutes. We are very interested in hearing your discussion. The standard 20 minutes per side will be followed, and we are very generous when it comes to, if we take your time, trying to make it right with you. So with that, counsel.
May it please the court, my name is David Abney. I'm representing Judy Koch Gullotty. I'll probably just call her Judy to make life easier for all of us in the future, with no disrespect to her or to the court. It's a case with a lot of interesting issues. The first one is the coercion issue. The trial court disposed of that pretty quickly by saying that there was absolutely no evidence in the record that would support the allegation that Judy was coerced into settling her case. But there was a great deal of evidence in the record to that effect. Judy specifically testified that she was pressured, that the...
She defined the pressure, counsel? What constitutes
She described the pressure. The pressure was the insistent phone calls, repeated phone calls, her attorney telling her that I can't take this case to a hearing. You're going to lose. You have to settle. You need to settle. You must settle, over and over and over. You know, we as lawyers have dealt with clients in many different situations, not just situations involving money, where the client really needs to think very, very, very carefully about settling. And where our inclination as lawyers is to say, settle this darn case. It's a difficult, hard case, and you're probably not going to do very well. But if the client says, no, I want to go forward, then you hitch up your socks and you go forward. There's a line there, of course, between being insistent and firm and making a solid, strong recommendation and coercing and pressuring so much that you overcome the will of the client under the particular circumstances of your situation.
The counsel, haven't we all run into the situation where you go into a case believing something to be true, believing something to be the linchpin of the legitimacy of your pursuit, and as that changes, don't you have to keep the client informed of your professional belief in regard to what the outcome of this case is going to be, and to the extent that they are bolstered by prior comments about how good the case looked, once the realities of the case kick in, don't you then have to be fairly ardent about how you re-advise the client for fear of running into malpractice challenges the other direction?
Yes,
you failed to tell me I was going to have these costs. You failed to tell me that you'd lost faith in the case once you talked to the expert. Isn't that a problem?
It is a problem, but not a problem for this case. It's a problem in general for the practice. It's very hard sometimes when you get into a situation and you think, well, something bad has happened, and I've got to talk to the client about this, and I've got to try to advise the client to settle and see what will happen. But if the client says no, you go forward.
But isn't there a difficult time finding when reality is interpreted as coercion?
Of course, it's very hard, and that's why it's something for the jury to do. The jury handles hard cases every single day, and this is simply another one. I don't know where to draw the line here. I can't tell you what was coercion and pressure that's improper and what is firm advice that is proper, but there is a line here, and once you pass that line, then it is coercion and pressure, and it's not right. You don't do that to your client. If your client says, I understand that you don't like my deposition answer. Let me explain to you what that was about. I had bursitis, and I didn't really regard that as an injury or an accident, and so I gave that equivocal answer. And I can explain that at the hearing, and we can go forward with this. And instead, the lawyer gets into a panic about this. Says, I can't go forward. I can't go forward. You're going to lose your case. You must settle. I can't succeed, which is as bad as advising your client that I'm going to succeed 100%. You know, it's bad either way. You just give your best opinion, but there comes a point when the client says, I understand, we're going forward. And you stop. You don't keep badgering your client. You don't keep pressuring your client. But where that place is, where that line is for the jury to draw. It's not for the judge to do when there is evidence.
To what extent, it seems like you're perhaps using, correct me if I'm wrong, but you're almost using coercion and pressure interchangeably. Are you? Those two? And just for context, I know you weren't trial counsel, but the motion for summary judgment, as I read it, moved for summary judgment on the claim/theory. I think it was more a theory than a claim, but coercion. Nothing was said about pressure. In response, it seems like to me, if you take the response and the oral argument discussion, that trial counsel almost treated the coercion aspect as an afterthought and told the Judge Whitten, hey, you got to decide this, almost conceding that the issue was not appropriate for a jury, but then relied heavily or somewhat on pressure and said, well, but my client was pressured, maybe not coerced, but pressured. What's the legal difference? Help me understand that.
I don't think there is a legal difference, and the trial counsel below could have been a little more energetic on this particular issue for sure. But you know, the problem is you can call it pressure, coercion, and say, well, this is justifiable coercion and pressure, or you can say this is coercion and pressure, and this is going too far, coercion and pressure. The words are not as firm as they can be. And that's the reason why you have a jury say, well, it's on this line, it's on the okay line, or it's on the not okay side of the line. And that's the problem here.
Wasn't your client allowed to say the magic words of pressure at least 2 or 3 times to the jury? I mean, was your client precluded from arguing or testifying that she felt pressured?
No, I think that she said that, but it mattered not at all, because that could not be a violation of the standard of care according to the trial judge. It didn't matter if she had gotten up there and said, I was pressured, I was coerced over and over. It didn't matter at all, because that part of the standard of care is gone.
But on who would have opined? Mark Harrison had not opined as to coercion. I don't think that was anywhere in his. Are you suggesting that the jury would have been instructed, like there would have been an instruction on coercion, or that would have somehow?
No, there would have been argument about that, and saying that this is the standard of care. And Mark Harrison did testify, and I cited it, opening brief 25 and reply brief 18, opening brief 25 and reply brief 18, where he said that repeatedly. Pushing and asking for her to settle was wrong, and as you go through the facts, to me it leapt out at me. How can you do this in a situation like this?
Do what? How can you
pressure and coerce your client to settle when the client does not want to do that? There's a line there, and I thought, if I were the jury, I'd say, you're way over the line, way over the line. But I understand other jurors could say, no, that's not over the line. And the problem is, by the trial judge saying there's absolutely no evidence in the record that support the allegations that she was coerced into settling. Absolutely no evidence. That's just wrong. There was evidence. And it's up to the jury to decide. Now, the trial judge may have said, well, I don't believe her. Or I'm weighing the evidence here. I don't find it convincing. I don't find it credible. But the trial judge can't do that. That's up to the jury to decide. And when the trial judge cut out this particular standard of care item, it had an immense effect. The case was bifurcated, after all. The defense wanted it bifurcated, and you wound up at the end with, were there any violations of the standard of care? And the jury says no. But if the coercion and pressure theory had remained in as far as a standard of care, the jury surely would have said yes, I would hope. that the jury didn't have the opportunity to do that. Of all the things that they did wrong, this is one of the clearest things that they did wrong. You don't go that far with a client.
Well, you don't go as far as your client says he went.
Exactly right.
As opposed to, did he go far enough that he knew his client was going to take a thumping and maybe have attorney's fees awarded and sanctions, and the attorney saying, look, the theory of the case has changed so radically that you're going to be harmed in far greater degree than you were ever going to be benefited by the potential outcome of the jury. I'm still struggling with that.
Well,
an attorney who says the theory changed so radically in this case that and the experts were wherever they were, that I would have malpracticed had I not really come down and let her know, how ugly it could get. How does that figure into it?
Well, I'm glad you're struggling with it, because the jury would struggle with it too. How do you clarify, based upon these facts and circumstances, what is too much and what is too little? The only way to do that is to go through it all and sit in a jury room with your peers and say and come to a conclusion of whether was it too much or was it not too much. They didn't get the chance to do that, and that's the problem here.
But I'm still struggling with the fact that I don't know. I'd like you to what specific evidence was the jury deprived of? Putting aside argument for a minute, maybe the counsel knew that he had to stay away from the word coercion or coerce, but
I don't think they were.
And he did say the word pressure in closing. I guess what evidence they presented the entire story, right, to the jury. The jury heard the whole story, from the nitty-gritty details of how this settlement came about, and the efforts to possibly set it aside, and then her efforts at going and talking to other counsel, et cetera, et cetera, et cetera. The jury heard a lot of evidence.
They did, and in fact, they heard a little bit more than was in the summary judgment stuff, because at trial, Pascuzzi frankly admitted, she told her, "I'm going to withdraw. I'm out the door. Have a nice day, unless you agree to settle." So there was actually a little bit more given at trial. It's not that they were deprived of the evidence. They were deprived of the opportunity to say that this was a violation of the standard of care. That's what was taken away, and that's what made this an unfair proceeding. That's what's missing here. Let's see. Not talking with the medical expert. There's another thing. Well, I was just shocked. You talk to your expert. This is your key expert in the case, and as it turned out, even though Judy didn't like this doctor a whole lot, and she thought he'd not did the best job in the world on her shoulder surgery, to put it mildly, the doctor would have been a tremendous witness. He said, yes, this is related to the work event. The surgery was necessary and reasonable. And it didn't matter that she might have had a problem before that with capsulizing the shoulder. What a wonderful witness. And Pascuzzi says, I had no clue what he was going to say. And I could not have reasonably had a clue what he was going to say. I think that's even in their answering brief. On page 55, quote, Pascuzzi did not know what Dr. Scalise's opinion would be and could not reasonably have known. What in the world? What lawyer would not talk to the expert? This is your expert. This is your case. At least call him on the phone if you can't take a few minutes to see the expert. Of course, you want to see the expert. You want to see how well the expert presents and speaks and communicates and understands, and whether the expert is on your side or against you. And she didn't do it. And she said, I didn't even know what he was going to say. Her plan was to send Judy to try to find out what the doctor was going to say. I never heard of a competent lawyer doing that either. You don't send your client off to do your work for you. You do your work. Failing to get a copy of the deposition transcript is a tougher thing to sell, even though things seem to be hard to sell here today. But it really is a tough thing to sell there, and I understand that. Except for, Pascuzzi said she was listening and taking extensive notes at the deposition, and she got this puzzling answer about a prior injury or problem with the left shoulder, and she noted it was a puzzling answer, but she didn't order the transcript. Well, if you're going to get in that sort of situation, The expert said, you need to get the transcript. Now, their expert sort of countered with a general statement, well, in workers' comp cases, we generally don't get depositions, which I don't understand, but they say they generally don't get them. Although they also say that the deposition's usually pretty short. An hour or so is about average, or maybe high average. But if you've got a situation where there's a puzzling answer, you need to get the deposition and have it corrected, address it with your client and correct it. There was an argument, there was a thread running through the briefing here from my colleague that the ethical rules are somewhat different for workers' comp lawyers, although occasionally they would come back and say, as answering brief at page 54, that the ethical rules are really the same. I submit to you they really are the same. I mean, I don't know what these workers' comp folks do in general, but you try to take care of your clients the best you can. And if a problem develops in a case, you don't head for the hills. You try to communicate with your client, find out what the problem really is, and address it. The one thing you could never do as a lawyer is simply just to give in and give up without asking your client, well, what's the problem here? Can you explain to me why you said X, Y, Z? And then try to address it effectively at whatever tribunal you're at. I think spoliation instruction, that's a hard one because it's what's for the standard of review for instructions is abuse of discretion. But here you've got a fascinating situation. You have a client that Pascuzzi called challenging, difficult, and unforgettable, and not in a nice way. And yet they started getting rid of stuff out of the file. I mean, why would you do that? You'd be adding stuff to the file. You'd be adding memorandums and capturing and saving emails and everything else you could to document what the client was doing. But here they got rid of the initial client meeting notes, which would have described exactly what Judy said about her medical condition. They got rid of a note where Judy had supposedly refused to pay for a report from Dr. Scalise. That was spoliated. And then there were supposedly these marvelously detailed handwritten notes that Pascuzzi took concerning the deposition, and they're gone. And that was the deposition where there was supposedly a puzzling answer. There should have been puzzling underlined with stars and everything in those notes, but the notes have vanished. There should have been a spoliation instruction. I think I'll burn a little bit of my time here on another thing. When I first came into this case and I read about this problem where Pascuzzi says, well, I found out that my client lied, I thought of the Japanese fleet in the Second World War. They had marvelous warships. They were fast. They were well armed. They were superbly officered. They were very, very aggressive, wonderful ships. Most of them were better than ours at the time, at the start of the war. And yet the one thing that they were bad on was damage control. If you hit a Japanese ship a few times, it would sink because they would run around. They wouldn't know how to deal with damage control. And then I thought to myself, well, that's not quite right. I know she did panic, and no wonder she hadn't even talked to her expert. But it was more like the Japanese commander of one of these ships who would keep on, I think a Japanese commander of one of these ships would actually keep on fighting to the bitter end, no matter what, and would never give up. And so it wasn't quite the right analogy, but it really struck me that this is not the way you handle litigation. If a problem comes up in your case, you work through it. You do good damage control. If you have to go down with a ship also, you'll go down with a ship. Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, my name is Jennifer Anderson, and I represent the defendants Therese Pascuzzi, Robert Taylor, and Taylor & Associates. I think the Court has already homed in on the key issues here, but I do want to clarify a couple things before I start. First of all, this case has never been about whether Ms. Gullotty wanted to settle, whether she was pressured into settling. She testified, and Ms. Pascuzzi testified, that Gullotty authorized a $40,000 offer to the carrier on July 26th. This was before Gullotty said all of this pressure and, strong statements occurred. So the issue here is not whether Gullotty was coerced into settling. It's whether she was coerced into settling for what was effectively for her $35,000 because Pascuzzi waived part of her fee. The other thing that I want to clarify is that at least at the summary judgment stage, Gullotty never argued that Pascuzzi said, I'm not going to take this to hearing. She never said Gullotty threatened to withdraw from the action. And indeed at trial, she denied that as well. She was specifically asked, did Pascuzzi say she was not going to go forward? And Gullotty testified, no, I don't think she went that far. On that same page of the transcript, which is page 117 of her testimony, she also said that on her own initiative, she consulted other lawyers and that she didn't just rely on Pascuzzi. At least at the summary judgment stage, the facts are a little bit different than have been painted. What I think is most concerning about Gullotty's argument is that under their theory, there's essentially no standard for when an attorney coerces a client into a settlement. In our motion, we proposed the standard for duress that's in the Restatement Second of Contracts, Section 175, where it requires a wrongful or an improper act that overcomes the client's free will and judgment and actually induces the settlement. And the reason why it's important not just to leave this to the jury and to require expert testimony on whether the act is wrongful or improper is because a jury is not going to know. In most instances, a jury is not going to know. It's not going to be obvious what's appropriate, strong recommendations and what is true coercion. And so, except in maybe a couple of outlying cases which don't apply here, you need an expert to testify what the attorney did was wrong, was improper, that was the basis of coercion. And Mr. Harrison never said in his declaration, and I would refer you to paragraph 17, what he said was Pascuzzi violated the standard of care by repeatedly recommending settlement when Gullotty needed a second surgery. It was substantively that she was recommending an unfavorable settlement, not that she was coercing Gullotty into settling.
Counsel, let me ask you a question following Mr. Abney's. I was thinking about the Yamato, when Japanese ships in World War II are somewhat an interest of mine. Did either of the experts testify that counsel, your client, should have just said, "Damn the torpedoes, let's go take it in the teeth on this"? Is that what attorneys are expected to do? Or is the attorney expected to get the best settlement they can, understanding the posture of the case? Did the experts ever go to that issue of when you cross the line from trying to get your client in the best posture possible based upon what the attorney has to work with, as opposed to just saying, hey, at least we'll be known for giving it the good old 1, 2, 3?
Well, absolutely not. And especially in the context of this case, that would be improper.
How improper is that? Is it an ethical problem if you say, hey, who cares if we make any money on this? Let's go make a social statement?
Well, I suppose you can consult with a client and let the client know that that's what you're doing, but I think that a conscientious attorney, a workers' compensation attorney who handles these cases all the time and knows that the credibility of the claimant is the central part of most of these disputes. You've got an expert on one side and an expert on the other side. And the question here is Gullotty believable that her continued pain and claimed need for treatment is related to the industrial injury?
Okay, so following the deposition, the news comes out, well, it's not entirely true that this is the first problem I've had with this shoulder.
Right.
In fact, I've had problems in the past, problems that continue to linger, problems that are associated more with the pain I'm feeling now than possibly the other pain that has just been suffered. Is it then the attorney's job before that gets worse? And then I'm trying to state this as best I can. Before that situation gets worse, do you try and get a settlement Or do you just say, hey, let's just hash it out. Let's go through it and find out exactly what the situation is and take whatever comes?
The first. I mean, clearly in this, and it's not just me saying it, it's Robert Wisniewski, who's a certified workers' compensation attorney who testified as an expert for Ms. Pascuzzi, who testified it was totally appropriate for her to recommend this $30,000 settlement. There was a good chance that Gullotty would get zero. And keep in mind, Gullotty wanted cash. She wanted to be awarded a sum of money. She never expressed an interest in just workers' compensation continuing benefits. I mean, she said things like, well, you know, medical care is expensive, blah, yada, yada, yada. But it was clear, especially from her authorizing a $40,000 settlement, she wanted a sum of money. She wasn't going to get that at the hearing, and she could very well have ended up with nothing if the ALJ decided that she was not telling the truth.
How about if the parties went forward and said, look, I need more clarification on this issue? Is that something that a claimant is going to do in this type of case? Say, now that this is out there, now that it's part of the discussion, boy, I want to flesh it out, and I want everybody to know exactly what the truth is, what the broadest scope of this is. Or are they saying, let's do the best we can given the record as it currently exists?
Well, I mean, Pascuzzi had no idea what else might be out there. I mean, if Gullotty would lie about, well, if Gullotty would misremember about this, what else is out there? And she had information that Gullotty was sort of a serial claims filer, et cetera, et cetera. So as far as fleshing things out, I mean, it's a workers' comp proceeding, right? I mean, it's, you know, it's kind of quick and dirty to a certain extent. And you get a hearing, and the doctors testify, the claimant testifies, the medical records come in, and the ALJ makes a decision. And there was a real chance that Ms. Gullotty was going to get nothing, and that's why recommending a settlement for effectively only $5,000 less than you originally offered, that was well within the standard of care to follow that course of action. I'm sorry, I'm not sure that answered your question, but...
No. In the category of been there, done that,
Okay.
I think it's a very tough call, and this is what I was concerned about with Mr. Abney, is at what point does it go from failing to give solid advice that the client needed in order to avoid a zero verdict, as opposed to, you know, at what point does it become coercion rather than giving good advice that's going to net the claimant something, the client something?
Well, and at the risk of appearing to dodge that question, I'm really not trying to. It depends. That's why you need expert testimony. That's why it's so important to have expert testimony saying, and you'll have experts on both sides. Yes, it was appropriate. No, it went over the line. And the jury can assess that. But the jury has no way of assessing what goes over the line in the typical case. Again, there might be extreme outliers, but this case is not one of them. And so that's why, and certainly at the summary judgment stage, nothing was presented in opposition to the MSJ that would, proving coercion, especially in light of Ms. Gullotty's verification under oath that she was entering into that settlement voluntarily, and on the day she signed it, she was not being coerced. I think that effectively, destroyed that theory of the case. And as the court pointed out, she had a variety of other arguments for why Ms. Pascuzzi violated the standard of care, including Gullotty claimed that Pascuzzi told her she could reopen her case later. That went to the jury, and the jury said no, that didn't. We don't buy it. So she had her day in court. She had her day in court. Moving on to the issue about obtaining Dr. Scalise's opinion. First of all, I do want to talk about the standard of review here, because I think the reply brief went a little off course here. Gullotty never argued that she was entitled to judgment as a matter of law on this or any issue. All right. She never filed a Rule 50 motion. She filed a motion for new trial in which the words contrary to law did appear, but the arguments were all couched as fact-based arguments, and the judge sitting as the 13th juror, et cetera, et cetera, et cetera. So this is abuse of discretion, and you're looking to see, did substantial evidence support the jury's verdict? Another point that I did want to touch on real quick, we've never argued that the ethical rules don't apply to workers' compensation attorneys. What we're arguing is that the standard of care is based on what a reasonably prudent attorney would do under similar circumstances. That's the key in this case. Workers' compensation is a different animal. Mr. Harrison has never done a workers' compensation case, whereas Mr. Wisniewski is a certified workers' compensation specialist. And he testified that the standard of care does not require that you personally meet with the attorney, that it is way common to give the claimant the option of meeting the doctor, obtaining, their opinion for free and quickly, especially, and this is appropriate, particularly in light of the fact that you're dealing with workers, some of whom are not working anymore, have limited resources and limited time. And the jury could simply accept Mr. Wisniewski's opinion over Mr. Harrison's, and that's just the bottom line on that. As far as the accusation that Gullotty had no idea what Dr. Scalise would say, I believe our brief has been mischaracterized a little bit. Ms. Pascuzzi testified that she assumed, until all these new records came in, she assumed that Dr. Scalise would testify consistently with his medical records that the surgery and other treatment were causally related to the industrial injury. It was only after these new records about the prior shoulder problems, it was only after they came in 2 or 3 weeks before the hearing is scheduled that she wasn't sure whether that was going to change his opinion. And so that's why she said, I didn't know his opinion. She didn't know it in light of the new records. She certainly didn't go on for months, having no clue, what the treating doctor was going to say. And again, that is appropriate and within the standard of care. As far as ordering the deposition transcript, that argument has been waived. It was not a part of any post-trial motions. Gullotty never moved for judgment as a matter of law on whether Pascuzzi should have ordered a transcript or had a read-in sign. It was not part of the motion for new trial, so that argument is waived. And as far as the spoliation issue, I think our brief addresses that pretty clearly, but if the court has any questions, I'd be happy to answer them.
I have a question for you for chronology's purposes. Once the deposition was held and the information came in about the prior injuries to the shoulder, what were the options for Ms. Pascuzzi at that point?
Well, the options for Ms. Pascuzzi were to try to settle, go to hearing. Those were about the two options.
So try to settle or go to hearing.
What about move to withdraw?
Oh, for Pascuzzi?
Yeah, withdraw from the case.
Well, I mean, Pascuzzi...
But sure, it was an option.
I'm sorry, I thought we were talking about Gullotty. For Pascuzzi, if she thought that it would be unethical to go to the hearing with Gullotty, that would be an option, yes.
You didn't flesh out the whole issue of what the potential prior injuries or the prior injuries had, what the potentiality was that the prior injuries had resulted in the current dilemma.
I didn't, and I guess I'm not sure that in the workers' compensation context they would. I suppose they could have requested a continuance potentially and tried to get some more information about that.
You were concerned about your expert going south on you. Are you going to go out and try and flesh that out all the more and make it a record that is going to be presented at trial to hopefully, if you're opposing Ms. Gullotty, that they're going to hand you your head is the best
right.
examples I can think of. Are you going to go out and develop that record Are you going to go out of your way to develop that record so then that is something more you have to deal with when your own expert says, I have no opinion at this point because I don't know what the scope of the prior injuries was?
Well, I don't think you would, because they had a theory that, they had a theory they could present, which was that that problem resolved 7 months before the industrial injury. And so the ongoing pain and need for treatment were related to the industrial injury as opposed to the prior injury. Now, if she had been upfront about that information, that might have been something she could sell, but the problem was that she wasn't upfront. The fact that she repeatedly denied to the carrier, to the employer, to her treating doctor, to the IME doctor, that denied any prior shoulder complaints, even though there was a record 7 months before the injury specifically referencing it. That's what just, sunk her case. I don't think it would have been a good idea to develop the record, and certainly there's no expert testimony saying that Pascuzzi should have, let's put it this way, there's expert testimony saying Pascuzzi handled it appropriately, and that is the testimony that the jury accepted. And for these reasons, the court should affirm. Thank you, Your Honors.
I don't think I'll ever be able to say all I want to say, but as far as the evidence at the summary judgment proceeding concerning the pressure, I set it out step by step with full citations on pages 11 to 14 of the reply brief. So that's a pretty good, very specific summary of all the evidence about pressure and coercion at that stage of the proceedings. As far as signing the written settlement agreement, that's always troubled me that they would say, well, after the oral agreement, you signed a written agreement, when they over and over argued, well, once you had the oral agreement, you were done. It was a final settlement. There was nothing you could do about it at that stage. So any documents she may have signed after that wouldn't have any effect on anything. Moreover, those documents are documents between her and the carrier. They weren't documents between Judy and her lawyer saying that I wasn't coerced as far as between the two of us, between her and the carrier. That's a different kettle of fish. Let's see. As far as whether the failure to get the deposition transcript in the review, the medical expert's testimony, and going out to get having a discussion with the medical expert, we set that out at page 25 of the opening brief. There's a good summary there of expert Harrison's opinions, page 25 of the opening brief that sets out the various standards of care and why he believes they were violated. And then the Yamato, might as well finish with the Yamato and a couple other Japanese ships. The true failings of the Japanese fleet really became evident at the Battle of Midway in June of 1942 when we hit 4 of their carriers and all 4 sunk. Now, we did lose carriers during the first parts of the war. The Lexington and the Yorktown come to mind specifically, but they had been actually repaired extensively and put back into battle after initial damage so bad that the Japanese thought they had been sunk. And that's one reason they were so surprised at Midway when the Yorktown showed up and put up a good fight before she did finally get sunk by a Japanese submarine in the end. And the Yamato was on a very brave but utterly suicidal mission. In 1945, the Japanese knew that their battleships were doomed if they went out without a carrier screening force, and they didn't have a carrier screening force anymore. So carrier-based planes hit her repeatedly with torpedoes and finally sunk. It was a huge number of torpedoes that went into her before she went down. But it wasn't because of damage control. That was just a damn fine ship, heavily armored and with a good captain and a brave crew, and they went down. They were doomed. And I hope my case is not doomed. Thank you very much for your kind attention.
Good use of your last minute and 40 seconds.
Thank you, sir.
I appreciate your argument today. I appreciate your willingness to address our questions. I know you came here. We've all been in your position, and I know you came here with a plan. And to the extent that we messed you up on that, I do apologize, but I hope you were able to get everything before the court that you wanted to say. We are going to take the matter under advisement at this time, and we will give our decision in due course. Thank you. We're adjourned.